What if I told you that same income could be taxed twice legally? Yes, once in the hands of the firm and again in the hands of the partner. Sounds unfair. That is exactly the controversy unfolding across India today. With rising tax notices, conflicting interpretations, and growing litigation, partners, especially in professional firms, are facing serious uncertainty. And now the Delhi High Court has stepped in, asking the CBDT to finally bring clarity. So today, let us break this down in a simple, structured way: what the law says, where the problem lies, and what this means for you. To begin with, the Income Tax Act actually provides a very well designed system to avoid double taxation between firms and partners. Here is how it works. The share of profit is taxed at the firm level and completely exempt in the hands of the partners. At the same time, remuneration like salary, bonus, or commission is allowed as a deduction to the firm and is taxable in the hands of the partners. So the intention of law is very clear: tax the income only once, but in the right hands. Where does the problem begin? However, things have taken a turn recently. Tax authorities across cities Delhi, Mumbai, Chennai, Indore, Bhubaneswar have started closely examining bonus and performance-based remuneration paid to partners. And what is happening? Reassessment notices are being issued, tax demands are being raised, and in many cases, the entire bonus is being taxed in the hands of the partner without considering whether the firm has already paid tax on it. This is where the real problem begins: the risk of double taxation. Now let us understand the legal backbone of this issue. Section 28, subsection 5 clearly states that any salary, bonus, commission, or remuneration received by a partner from a firm is taxable as business income in the hands of the partner. And this is the provision tax authorities are heavily relying upon while raising these demands. But that is only half the story. We also need to look at section 40, subsection B, which is equally important. This section governs how much remuneration is allowed as a deduction to the firm. It sets specific limits, and if the firm pays anything beyond those limits, that excess amount is disallowed. And here is the key point: that disallowed portion is already taxed in the hands of the firm. So, when you read section 28, clause 5 and section 40, clause B together, the correct legal position becomes very clear. The remuneration should be taxed in the partner's hands only to the extent it is allowed as a deduction to the firm. If any portion is disallowed under section 40, subsection 5, it has already been taxed at the firm level and should not be taxed again in the partner's hands. This ensures one fundamental principle, that is, no double taxation. Where things are going wrong, but in practice, this is what is not happening. But in practice, this is not what is happening. Tax authorities are taking a simplified and arguably incorrect approach. They are taxing the entire bonus or remuneration in the partner's hand without verifying whether it was allowed or disallowed in the firm's assessment. And that is exactly what is leading to double taxation and disputes. Nature of bonus. Now let us understand why this issue has suddenly come into focus. Partner bonuses today are often performance linked and variable in nature, sometimes even higher than the share of profit. Because of this, tax authorities have started scrutinizing such cases more closely, especially where partners report large exempt profits along with significant bonus income. Taxpayers' arguments and judicial support. Taxpayers, however, are strongly challenging this position. Their argument is simple: you cannot apply Section 28, Clause 5 in isolation while ignoring Section 40, Clause B. The law does not allow the same income to be taxed twice. And importantly, this view is also supported by judicial precedent, including a 2022 ITAT ruling, where it was clearly held that double taxation in such scenarios is not permissible. With this background, the matter reached the Delhi High Court. A partner from a leading professional firm challenged these tax proceedings. After the court recognized that this is not just one case, it is a significant legal issue affecting taxpayers across India. So, what did the court do? Granted interim relief, stayed tax recovery proceedings, and most importantly, directed the CBDT to examine the issue and issue clarification. Why this case is important? This intervention is extremely important because generally high courts do not step in when alternative remedies exist under tax law. But here the court made an exception because the issue involves a pure question of law with widespread impact requiring uniform interpretation. That clearly shows the seriousness of the matter. What to expect from CBDT? Now all eyes are on the CBDT. A fair and logical clarification would state that only the portion of remuneration allowed as deduction to the firm should be taxed in the partner's hands, and the disallowed portion should not be taxed again. However, if a stricter interpretation is taken, it could lead to continued litigation and higher tax burden. Practical impact. This issue directly affects CA firms, law firms, consulting firms, LLPs. Many partners may already be facing reassessment notices, tax demands, ongoing litigation. Although the High Court interim relief provides temporary protection, the final clarity from CBDT will be crucial. To sum it up, this entire issue revolves around one fundamental principle, that is, the same income should not be taxed twice. While the law under Section 28, Clause 5 and Section 40, Clause B supports this principle, the current approach of tax authorities has created confusion and disputes. Now the final answer lies with the CBDT, and their clarification will decide the future course of this case. This is C&IP Praveen Agrawal. I hope you found this explanation clear and valuable. Stay connected for more insights on taxation, law, and business development. Thank you so much.